Good morning.
Good morning, Your Honors. I'm Klein Preston of the National Bar.
All right.
I represent the petitioner and the appellant in this matter, Mr. Kromah. This is a unique case, at least in my practice, in that Mr. Kromah has the unfortunate position to actually be innocent. And
Do you want to reserve any rebuttal?
I'd like to reserve 5 minutes.
5 minutes.
Please, Your Honor.
All right, go right ahead.
Which I think is the overriding most important factor in this matter. Admittedly, there are some procedural problems and technical problems with this case from the trial court and on appeal. However, Mr. Kromah was evicted of one count of sexual battery in 2011. This court upheld the conviction in 2013. He served his time, both incarceration and then probation. It was a 4-year sentence. He served his time. Now he's on the sexual offender registry. He brought this matter originally it started in 2016, and therein lies the procedural and technical problems, because the alleged victim, who is actually here today, recanted her testimony in 2016 and again in 2017, and she has maintained that recantation for the last almost 8 years. In doing so, the 1-year statute of limitations was triggered, and it was not met. And so we find ourselves here today. Judge Tidwell in Rutherford County heard the proof and dismissed it based on the statute of limitations, the 1-year statute of limitations, and he found that there was not a basis for an equitable tolling of the statute of limitations. Admittedly, all the factors are not present for an equitable tolling to extend the statute of limitations. However, there are a couple things that I think distinguish this case from other cases that Your Honors have heard. Number one, which is one of the fundamental elements, whether you're applying the standard in Workman or Clardy, in this case we do have actual innocence. And so that I would submit as the most important factor. But this case is distinguished because Mr. Kromah continues to be punished. This case has not ended for Mr. Kromah. His probation has been completed, his incarceration period has ended, yet he remains on the sex offender registry and is continuing to be punished and suffer because he has not been successful in removing number one, the conviction, and then number two, he remains on the registry. Based on that, and there is no case law to support this, but by analogy, in civil cases, you can have what's called an ongoing tort. There's continuous harm that's continued. In this case, I would say by analogy, Your Honors, that we have a continuing harm or continuing punishment to Mr. Kromah because he remains on this registry. And so we would respectfully submit that the trial court should have extended the statute of limitations through an equitable tolling of the statute based on the fact that he continues to be on the sex registry. That makes this unique, respectfully, although as to now there is no proof or no precedent that would support our contention. However, we respectfully suggest and request that the court look at the facts in the totality and the harm that's being accomplished. The central question here, really, and I understand the court's need and the necessity and desire to have finality in cases. The courts don't want to have every case relitigated ad infinitum. Otherwise, it would just grind the system to a halt. However, in an instance where we actually have the most important element before the court that has not been challenged by the state, that Mr. Kromah is actually innocent of the charges, for which he's already been punished, he's already served time, he's already served his probationary period, and he continues to be punished, we respectfully submit that the court should create and extend the equitable tolling aspect that would permit the case to proceed upon remand in the trial court so that he could have his conviction reversed. Admittedly, I have no precedent to support the contention. Respectfully, we submit that the court use its equitable powers and extend that the holdings in cases wherein the statute in this sort of instance has run on the bringing of a petition for writ of error quorum nobis. And in this instance, if we respectfully submit that you extend the equitable tolling to permit a case to be brought at any time that there's still a punishment being meted out or suffering. In this case, he would be on the sex registry for life. And so, respectfully, I would ask your honors to reverse the trial court, find that Judge Tidwell abuses discretion in not extending the equitable tolling.
What do you say about the state's argument that the case should be dismissed because the notice of appeal was late?
Well, there are different dates on this. I was hired after it was already in this court, but based on what the record appears to say, is there was an order that went down in October. I think it was October 22nd. Then this notice of appeal was filed on November 20th of the same year, and less than 1 month later. However, even if that is not the case, they applied a September date. Even if that is not the case, this case, respectfully, I would submit would fit well within the exception under a waiver theory. That, I mean, the fact that this case is Mr. Kromah is actually innocent should bear a lot of weight here, because we're not hearing any, and there is no proof otherwise. We have the person who recanted their testimony, and that should supersede form.
Well, this is not the first case where a victim has recanted testimony. We see these, fairly often. And I assume this victim testified under oath before the jury that found the defendant guilty. Is that correct?
Yes, Your Honor.
And so, no offense, but the issue becomes, was the victim telling the truth then, or is she telling the truth now? And to say that he's actually innocent is a little bit of an overstatement, at least at this point in time.
I understand your concern, but the relief sought in a petition for writ of error quorum nobis is we're asking just that it be addressed on the merits again. So it wouldn't be just a superseding decision to say, oh, well, he's not guilty this time. The court would still have a procedure in place to address that very concern, Your Honor.
Of course, the writ was filed 8 years after the affidavit, I believe, was the first time that the victim said she did not tell the truth at trial, correct?
That is true, yes, Your Honor.
What was am I reading this correctly, that was a deposition that was taken in 2017?
I believe it was in 2016.
What was
2016 or 2017.
What was the context of that?
To establish proof. That was another attorney who did the deposition, but to establish proof that she was recanting her testimony.
Well, I think deposition, though, I think there's some sort of judicial proceedings taking place. Was there anything going on back then related to this case in court?
I'm sorry, Your Honor.
No, you're fine.
Only this, or the preparation for a petition such as this.
Okay.
And there was also, she also has also submitted to affidavits in addition to the deposition. Actually, so I think we have 2 affidavits and then one deposition. But I would also, if I might address, Your Honor, raise an issue about the timeliness or untimeliness of the notice of appeal. case that was cited by the state, I believe it was Mixon. In that case, it's distinguishable because that case, in addition to there not having been a timely notice of appeal filed, the record was not a workable record. And so I think on that case, they couldn't even address the merits.
But none of that is in your principal brief, correct? None of that information, unless we.
That's in the
figure
state's
it.
brief, Your Honor.
I understand, and you didn't file a reply brief.
I did not.
With
on
those type of arguments, correct?
No, Your Honor. Unless someone has any questions, I'll cede my time.
All right.
Thank you, Your Honor.
Thank you. Good morning, General.
Good morning, Your Honors. Thank you. May it please the court, Lacey Wilbur on behalf of the state. Your Honors, this court should dismiss this appeal because the notice of appeal was untimely and the merits of the underlying petition for writ of error coram nobis are without merit. So what we have here is we have the defendant filed with the assistance of counsel a petition for writ of error coram nobis, had a hearing, and at that hearing, counsel, I think in between the time of filing the petition and the hearing, I think he learned that this was not newly discovered evidence. So he did not even make that argument at this hearing and said, we would just like a ruling on this, Your Honor. And so the trial court said, okay, it's untimely, so I will deny it on the grounds of the statute of limitations. And that order came down on August 19th, 2024. The defendant did not file his notice of appeal until November 20th, 2024. What we have in between those two dates is this second pro se petition in which the defendant it was a check the box kind of document, and it talks about one box is waive court fees, one box is extend probation. He checked other, and again, this is pro se, and he just said, he laid out that he'd been convicted of sexual battery by an authority figure, and he would like to not be serving the consequences of that. And then if you take, in the trial court, they did actually have a hearing on this, and at that hearing, the defendant said, I would like an expungement, and the court said, I'm sorry, I can't do that. Then the defendant said, I would like to be taken off the sex offender registry. Trial court said, I cannot do that. And then the defendant talked about something about he was on Class C, and the trial court said, I'm sorry, I can't do that. So he put down an order denying that pro se petition in October. If we get to the merits of this, this is not newly discovered evidence. As Your Honor noted, the first affidavit we have is dated 2016, and that is where she recants her testimony. We have a deposition, which was only a deposition for the purpose of getting this into some sort of record, and the defendant was present at this, and that was in 2017. And then she writes another affidavit in 2024, and that's what he's trying to latch on to that date. So what we have here is the defendant just keeps getting the victim to file a new affidavit to try, but it's not newly discovered evidence because he knew back in 2016. And with respect to actual innocence, in the record at the hearing on the petition for writ of error coram nobis, that first hearing, the prosecutor introduced a memo to the file that he had written on this case because he was disturbed that the victim had recanted her testimony. So he called her into the DA's office and interviewed her. And in that interview, according to his memorandum, she said, my trial testimony was true, but the ongoing consequences that my dad is suffering are too harsh. So there is no actual innocence in this case. And again, there is no newly discovered evidence because it's 8 years old. He'd never filed a petition for writ of error coram nobis within 1 year of the 2016 affidavit, 1 year of the 2017 deposition. And so, Your Honors, we ask that you dismiss this appeal as untimely, but in the alternative, you affirm the judgment of the trial court if you have no further questions. All right, thank you, Your Honors.
Thank you. All right. Thank you, Mr. Preston. Both briefs are well written. We'll take this under advisement. And let's take about a 10-minute break, and then we'll come back and pick up the other case.
All right.